Hi everyone. So this is CA Harsha. So today we are going to discuss about a very important as well as also a controversial topic under GST, that is arrest under GST. Now why it is a controversial and all you will slowly come to know by the end of this video. Now before proceeding, I will just try to quickly give you a helicopter view or a bird's eye view about what I am going to cover in this video. That I am going to cover the basic section 69 of the CGST Act and also the instructions, also some case laws regarding arrest under GST, and finally constitutional aspects. Okay, so this is my coverage in this video. Now quickly we'll start with the section 69, that is power to arrest. Now this is a basic section which had given the power for the officers, that is commissioner in GST, to arrest. So where the commissioner has reasons to believe that a person has committed any offense specified in clause A, B, C or D of subsection 1 of section 132. Now what is this clause A, B, C and D? So let us have a quick look about the offenses getting covered under clause A, B, C and D. Now clause A supplies any goods or services, okay, without issuance of any invoice. That I have supplied the goods but I didn't issue any invoice with an intention to avoid the tax. And the second one, I have issued invoice or bill but I hadn't actually made any supply. That is fake invoice I have issued. Okay, I am issuing the invoice but actually there is no any supply, fake invoice. C, clause C, that is availing ITC based on the above referred fake invoice or fraudulently availing the ITC. Last one, I have collected the GST but I have failed to pay the collected GST to the government within 3 months. So these are the 4 offenses which are getting covered under clause A, B, C and D of subsection 1 of section 132 of the CGST Act. Okay, now what section 69 is saying, that any offences specified in clause A, B, C and D of 132 subsection 1 which is punishable under clause 1 or 2. No, just because you have done this specified 4 specified offences, I cannot arrest you. Again, that should be punishable under clause 1 and clause 2 of 132 subsection 1. Now when it will be punishable under clause 1 and 2 of section 132 subsection 1? If you go and refer here, clause 1 and 2 of 132 subsection 1. Simply speaking, where the amount of tax evaded or the amount of tax input tax credit wrongly availed or refund wrongly taken exceeds 500 lakh crores, 500 lakh rupees they have said, we can take it as 5 crores. If the amount exceeds 5 crores and if the amount exceeds 200 crores but does not exceeds 2 crores and 5 crores. Simply speaking, they have referred 200 lakhs and 500 lakhs. It is 2 crore and 5 crore. We can easily refer. So if you will be punishable under clause 1 and clause 2 based on the amount involved, tax amount involved, not the transaction value, tax amount involved. So arrest under section 69 can be possible if you have committed any of the specified offences, that is the 4 offences, and it should be punishable under clause 1 or clause 2. When it will be punishable under clause 1 or clause 2? If the amount exceeds 5 crore in one scenario and the other scenario the amount exceeds 2 crores. Then arrest can be made under section 69 of the CGST Act. And also they have referred subsection 2 of section 132, which is talking about the repeated nature of offences, that I am not going to cover. Okay, so this is broadly where the commissioner will have the power to arrest. Okay, now before proceeding to the next aspect, I just want to give you a quick overview about the offences under GST. Now the offences under GST can be broadly classified into 2 categories. Offences in GST can be broadly classified into 2 categories. This classification has been done not by me, by the section 132 subsection 4 and section 132 subsection 5. Now let us quickly have a look about what section 132 subsection 5 is saying. Now section 132 subsection 5 is saying that the offences, see these 4 offences I am referring as specified offences. These specified offences when punishable under clause 1, when it will be punishable under clause 1? If it exceeds, if it is 5 crores or more, the amount, tax amount involved is 5 crores or more, then only it will be punishable under clause 1 of section 132 subsection 1, shall be cognizable and non-bailable. So I can write here that these offences getting covered under clause A, B, C and D of 132 subsection 1, and amount involved is 5 crore or more, then these offences are what? These offences are cognizable and non-bailable. Now remaining all offences under GST are non-cognizable and bailable. I hope it is clear. So these clause A, B, C and D which I have referred, that supply without issuing invoice. Second one, no issuing invoice without any actual supply, availing ITC based on that fake bills or fraudulently availing ITC, and the last one, GST collected but failed to pay to the government within 3 months. All these 4 offences, if I have committed any one of that offence and it is punishable under clause 1, when it will be punishable under clause 1? If the tax amount involved is 5 crore or more, it is getting covered under clause 1 of section 132 subsection 1, then it will be a cognizable and non-bailable offence. Remaining all offences under GST are non-cognizable and bailable. Now what is the differentiation and all? I will explain. Differentiation between cognizable and non-cognizable I will explain. But why I have bring this classification was, if you refer subsection 3, now what it is saying, that where a person is arrested under subsection 1 for any offence specified under subsection 4 of section 132, he shall be admitted to bail or in default of bail forwarded to the custody of the magistrate. So if you have committed any offence getting covered under 132 subsection 4, you will be getting a bail. Okay, so that is the reason why they have used the word here, bailable offence. Now here it is the offences getting covered under section 132 subsection 5, they are non-bailable and cognizable. Now let us discuss the differentiation between cognizable and non-cognizable offences. In general, always you have to remember one logic, that cognizable offences means serious offences. Now where arrest can be made without any warrant. In cognizable offence, the enforcement authorities of that particular law can arrest you without a proper warrant. Then I will call it as cognizable. If you observe these specified offences, GST Act is considering them as serious offences, and if that too the amount should be more than, tax amount should be more than 5 crores, then I can arrest you without any warrant, and getting bail also will be difficult, non-bailable. We cannot say that bail cannot be, bail will not come, but getting bail is difficult. You cannot claim it as a right. But remaining all other offences are non-cognizable and bailable. Okay. Now I hope up to here it is clear. Now let us come to another important subsection, that is subsection 2 of section 69 of the CGST Act, where a person is arrested under subsection 1. Now when I will be arrested under subsection 1? If I have committed any one of that 4 offences and the amount involved is 5 crores or more or 2 crores or more also. Why? Because clause 2 also is there here. Okay, I am referring about subsection 2, not about that classification of non-cognizable, bailable, cognizable and non-bailable and all. Okay, there they have considered only clause 1. But here subsection 2 may what they have said, where a person is arrested under subsection 1 for an offence specified under subsection 5 of section, the officer authorized to arrest the person shall inform such person of the grounds of arrest. So what they are saying, subsection 1 of section 132 means what? These offences only, no? Now whenever I am making an arrest for offences getting covered under section 132 subsection 5, what they are saying, the officer authorized to arrest shall inform the grounds of arrest. So if you refer here the word, they have simply used the word shall inform such a persons about the grounds of arrest. It means, let us assume if I am an officer and a taxpayer had committed an offence which is getting covered under section 132 subsection 5, me being an officer should have to inform him the grounds of arrest. This is what it is saying. Shall inform is the word they have used. Now this grounds of arrest is a very important aspect. Recently, not recently, in the year 2025, the CBIC had issued one instructions regarding arrest. Earlier, one instruction was issued in the year 2022. In that instruction, they have made an amendment through another instruction which was issued in 2025. Now, before we going to discuss this grounds of arrest aspect detailedly, we have to understand that instructions, because in that instruction something about grounds of arrest was there. Okay, so let us look at that instructions. Now this I have briefly written the matter getting covered about that instructions regarding arrest. CBI has issued an instruction in the year 2022, first instruction, in which it is stated that grounds of arrest must be explained to the arrested person. I have to explain him the grounds of arrest. See, what is grounds of arrest I will explain, but as of now you just understand the wordings that grounds of arrest should have to be explained. Okay, next one. And this fact should be noted in the arrest memo. Whenever arrest has been done, an arrest memo will be issued. In arrest memo, this fact should have to be come that the authorized officer had explained to the arrested person about the grounds of arrest. Okay, so this is what that instruction had said. What instruction had said? The grounds of arrest must be explained. Okay, later this instruction was amended on 13th January 2025. Now what they have said, the grounds of arrest must be explained to the arrested person and also furnished to him in writing. This is a new point as an annexure to the arrest memo. Earlier I have simply said that no, the grounds of arrest should have to be informed. Even section 69 is also saying, instruction is also saying that grounds of arrest should have to be informed. But what the amended instruction is saying, the amended instruction is saying that furnish him in writing the grounds of arrest. Now this, and also it should have to be attached as an annexure to the arrest memo. This is what it is saying. Now why this change had came, and what is the importance of the word grounds of arrest, and what is the difference between reasons to believe and grounds of arrest. These aspects we are going to discuss in detail because this is very much important. Now the reason for department issuing this amendment or the issuing this new instruction was a judgment given by the Delhi High Court. Delhi High Court in Shedjit Girdwala, I think, I am not sure about the name. So you can refer in that instruction, the name is there. So in that, the Delhi High Court, in that judgment, the Delhi High Court had categorically said that the grounds of arrest should have to be communicated in writing definitely. Categorically, the High Court had said that the grounds of arrest should have to be communicated to the arrested person in writing. Okay. Now, why? There was a discussion about these aspects. Let us refer that paragraphs what they have referred. Okay. Now, there is one important judgment called Pankaj Bansal versus Union of India. In that Pankaj Bansal versus Union of India, the Honorable Supreme Court had clarified why the communication of grounds of arrest is very important. Okay, so let us look at this. See, the communication of the grounds of arrest is not only to apprise the arrested person of why he or she is being arrested, but also to enable such person to seek legal counsel. Now, legal counsel means taking a legal aid from an advocate. Now, grounds of arrest not only to tell you on what grounds we are arresting you, it is important even for the arrested person to take a legal aid. Next one. In the event their grounds of arrest were equally voluminous, it would be impossible for either Pankaj Bansal or Basant Bansal to record and remember all they had read or heard being read out for future recall so as to avail legal remedies. What actually happened in this case was the grounds of arrest was not given in writing, it was informed. Informed in the sense they have read it out. the officers had read it out before the arrested persons, that is Pankaj Bansal and Basant Bansal. What they are saying was, what the court had said, that you said that you are reading out, this reading out and all is generally the grounds of arrest can be highly voluminous, and it would be difficult for the arrested person to record and remember all they had read or being heard out for future recalls, because tomorrow I have to explain my advocate. You didn't give any grounds of arrest in writing. No, you have just explained me, or you have just read it out. No, I have to remember all those things and I have to explain to my advocate. No, it is practically not possible for me to remember all these things and to recall and to explain before my advocate. And also they have very importantly, they have highlighted that a person who has just been arrested would not be in a calm and collected frame of mind. See, my state of mind would be very different at that time. I will be in a complete shock. Okay, when you are arrested. Now at the time, whenever you are reading out the grounds which are highly voluminous and highly technical, how can you expecting me to remember and recall them and explain them to my advocate for seeking a legal aid? So this is the reason why communicating the grounds of arrest in writing is very, very important. And may be utterly incapable of remembering the contents of the grounds of arrest read by or read out to him or her. So the Supreme Court had categorically highlighted that the grounds of arrest should have to be given in writing. Now they have also given the reasons for why it should not be read out. Because you being reading it out before the arrested person, he may be incapable of recollecting all those things. Okay. Excuse me. So this is about this judgment, that is Pankaj Bansal versus Union of India. So in this we have understood why mere reading out is not sufficient, writing is important. And also there was another important judgment, that is Prabir Purkyasta versus State National Capital Region, Delhi. In this judgment also there is an important part. What is that? This information would be only effective means for the arrested person to consult his advocate, oppose the police custody remand and to seek bail. So what they are saying, the communicating the grounds of arrest properly in writing is the only effective means for the arrested person to consult an advocate. Okay. And also what they have said was, see, this grounds of arrest was not only given in any law, or was not only simply said by the court, it was part of Article 22 of the Constitution of India. Rights of the arrested person. Okay, it is a fundamental right that whenever you are arresting me, I have a right to know the grounds of arrest, why you have arrested me. Okay, so that is what they have highlighted. Article 22(1) and Article 22(5) of the Constitution of India is sacrosanct. Now, what do you mean by the word sacrosanct? Sacrosanct means there is no exceptions, you have to follow it and cannot be breached under any situation. So, as Article 22(1) and Article 22(5) of the Constitution of India being a fundamental rights is stating that the grounds of arrest should have to be communicated in writing. It should be followed by any law. Non-compliance of these constitutional requirements and statutory mandate would lead to the custody or the detention being rendered illegal. If you are not following this, then the arrest would itself will become illegal. Okay, so considering all these aspects, see, I will try to explain you with this importance of communicating the grounds of arrest with a very small example. For example, you have said that I have done one offense. Now, you being an investigating authority, you will be having a lot of understanding that how that offense had done and what is my role and what I have done. If you have communicated that, then I can counter that your argument in the court of law. If you are not giving the basis on which you are saying that I have committed an offense, how are you expecting me to counter your argument in the court of law? So for an effective legal aid, this is very much required. if you if you are sorry, excuse, if you are not giving that grounds of arrest, you are depriving my fundamental right. And also remember that article 13 is there. Article 13 of the Constitution of India is there to protect the fundamental right. As per article 13 of the Constitution of India, any law restricting the fundamental rights of the citizens, that law itself will be void. So any law which is contrary and abridging the fundamental rights, that law itself will be void. To that extent, this is what article 13 is clearly saying. Now in your GST law you have said that no, grounds of arrest need not to be given in writing. Grounds of arrest we will tell it orally. No, you are violating my fundamental right which is given under article 22. So the moment you are violating my fundamental right, that provision itself will not be valid. That your 69 subsection 2 will not be valid. So this is what the importance. So if you are communicating like how I have committed that offense, you have communicated, then I would counter it properly. Okay. So this is what the importance of grounds of arrest. That is the reason why after the Delhi High Court judgment, which categorically said that the grounds of arrest should have to be communicated, this is what the discussions they have referred. Okay, Pankaj Bansal and Pravish Purikshata, these judgments they have referred, and also they have referred another 2 to 3 judgments. No, the only relevant extracts I have brought here. So considering all those judgments, the Delhi High Court had said that the grounds of arrest should have to be communicated in writing. Accordingly, CBIC had amended the instruction. Now I hope it is clear that why the instruction was amended from the wordings that grounds of arrest should be informed to the grounds of arrest should have to be given in writing as an annexure to the arrest memo. I hope it is clear. Now it is time to understand the difference between grounds of arrest and reasons for arrest. This is very important. Grounds of arrest and reasons for arrest. Now first we will come with the reasons for arrest. Reasons for arrest are very generic in nature. So in general, arrest, why arrest will happen? Na? So say for example, an accused person is there. No, reasons for arrest generally will be like, to prevent the accused from continuing fraudulent activity. No, to prevent him from doing further fraudulent activity, we have to arrest him. And to prevent the accused from tampering evidence. No, if he is if he is kept free, he may tamper the evidence. This is one reason why we want to arrest him. And the other one was to secure the presence of accused in court proceedings. Now, if we didn't arrest him, he may leave the country. There is a flight risk. Flight risk, tampering evidence, non-cooperation to the investigation. These are the general reasons where arrest is required. These are generic in nature. Reasons means these are the examples. These are very generic in nature. Grounds means very specific and personal to the case. Okay. So what grounds looks like? I have given one example. So grounds are very specific and personal and exact reasons and fact that lead authorities to believe the person has committed the offense. Now what are the factors that had made the officers to believe that you have committed an offense? Example, there was a example of fake ITC case. Now fake ITC case may, for example, there was an allegation that I have taken a fake ITC. Now what will be the grounds of arrest? The grounds of arrest can be like this. These are the list of invoices you have purchased from a party. This party we have verified and is actually not doing any business from that registered premises. Now you have purchased these many invoices from him, you have procured. As that person is not doing the business, your whatever the invoices, whatever the list of invoices we have given and whatever the ITC you have availed based on all these invoices, it is a fake ITC. And also to confirm that they have given some statements of the co-accused or the other party, and also they have brought the bank statement confirming that there was a circular trading happen. Now circular trading happening in the sense, I can give you a small example that A and B is there. A had supplied some goods, not supplied, actually they have given a fake ITC case, fake invoice they have given. B had availed ITC based on it. Okay. Now to show this transaction as real, B will make some payment to A. Now what A will do? A will again reroute that money to B, but not directly. A will first reroute to C, from C to D, and again from D to B. They will do that. Circular trading. No, department had identified or analyzed all these persons' bank statements, and they have come to the conclusion that no, there is a circular trading happening. Now see, I have explained grounds of arrest can be like this. Your supplier is not doing the business. Now these are the invoices, list of invoices that which you have purchased from him, and also we have an evidence that your bank statement had revealed that there was a circular trading happened, and also there was a statement given by your co-accused or the supplier confirming the fraud. All these are the examples of grounds of arrest. Now if you give the grounds of arrest properly, I will understand what you have identified or what made you to believe that I have involved in the fraud. Thereby I can counter your point very effectively. My advocates or my legal team, or I can provide a supporting information to my legal team so that they can put an effective argument before the court of law. Without you giving all these grounds properly, how you are expecting me to counter the points effectively in the court of law? These cannot be done effectively without the proper grounds of arrest given. So this is the reason why grounds of arrest is very, very important. Reasons for arrest are very general in nature. Okay, like flight risk, he can tamper the evidence, he may involve in further fraudulent activity, he may not appear before the court for the proceedings. Stating all these reasons, I can do the arrest, but the grounds are very different. Okay, grounds are very special in nature, and I have given some examples also, I think. Okay, so I hope you have clearly understood why the grounds of arrest, communicating the grounds of arrest is very important. Now coming to the reality aspect, in many instances, the GST authorities fails in communicating the grounds of arrest properly. So if the grounds of arrest has not been communicated properly in writing, that itself can be a ground to save the person from arrest. Okay, so this is one aspect. I hope we have covered about the grounds of arrest. Now in this we have already covered about Article 22. Now there is another constitutional aspect, that is Article 21 related discussion. Now Article 21 had given all the citizens a right to life and personal liberty. Now whenever an arrest is happening, it means that you are taking the personal liberty from me. You are taking the right to life and personal liberty from me. So this is what arrest always takes out right to life and personal liberty from you. Now a fundamental right being taken away. Now whenever a fundamental right is being taken away, the courts will analyze, or the courts will look into it very seriously, because the apex court or the courts are there to protect the fundamental rights of the citizens of this country. Okay, now what Article 21 is saying: no person shall be deprived of his life or personal liberty except according to the procedure established by law. It means that I can take out your personal life and liberty only by following the procedure established by law. Without following the procedure established by law, I cannot take out your right to life and personal liberty. Okay, but now what is meant by procedure established by law? So before going detailedly about procedure established by law, I want to explain you a very important Supreme Court judgment called Maneka Gandhi versus Union of India. This was a Supreme Court judgment. In this Supreme Court judgment, what the Supreme Court had said was, if you refer the article, the word used here was procedure established by law. But what the Supreme Court had said in the Maneka Gandhi versus Union of India case was, due process becomes synonymous with the procedure established by law. It means that even though the word used in Article 21 is procedure established by law, we will consider it as due process of law also. Okay, now what is this due process? What is this procedure established by law? Let us understand. Due process versus procedure established by law. Now, coming to first the procedure established by law. For example, now in India, if you take an example that arrest of a person, now for doing an arrest, a certain procedure should have to be followed. Now what procedure should have to be followed? Procedure given under CRPC, that is a code of criminal procedures. Criminal procedures code, whatever the, and currently we are also using BNSS. Okay, now whatever the procedure has been established by law, that procedure you have to follow, then only you can arrest a person. This is what Article 21 also said. Now procedure established by law means whatever the procedure law had given, that you have to follow. The moment you are following the procedure given by the law, the arrest you have made is valid. Okay. Now the government has authority to set up the procedures and process for implementing and enforcing these laws. Under this, as long as the government follows the procedures it has established, its actions are considered valid even if they appear unfair or unjust. Now whatever the procedures you have given in the law, the moment I am following all those things, the arrest that I have made is proper. Okay, this is what procedure established by law. What is due process of law? Now in due process of law, the procedures adopted under law should be fair and just, and it shouldn't be arbitrary. Now what is the difference in procedure established by law and due process of law was, in procedure established by law, I will check only whether you have followed the procedure or not. In due process of law, I will check whether the procedure given in the law itself is correct or not. Whether the procedure given in the law itself is fair and just, and it should not have any arbitrary action. Arbitrary action means doing as per their own wishes without any proper, or I can say that without following the principles of natural justice. An arbitrary action means. So in India, whenever here comes the important point. I hope you got the difference between procedure established by law versus due process of law. Procedure established by law, the moment you have followed the procedure given in law, fine. But in due process of law, I will check itself whether the procedure itself is correct or not. In procedure established by law, you followed the procedure, okay, fine. In due process of law, whether the procedure itself is correct or not, I will check. That is the difference between procedure established by law and due process of law. Now, what Article 21 is saying, whenever you are taking away any person's right to life and personal liberty, you have to follow the procedure established by law. This is what Article 22 is saying. But the Supreme Court in Maneka Gandhi versus Union of India had said that even though the wordings are procedure established by law, we will read it as due process of law. We will read it as due process of law. It means it can be CGST Act or it can be any other act. It can be CGST Act or it can be any other act, or any instructions given by the CBIC. Following that itself only will not be sufficient. Whether that instructions or whether that law is following the principles of natural justice, whether that law itself is fair and just, that also we will look. Who will look? Supreme Court will look. This is what given in Maneka Gandhi versus Union of India. Now I will come to the point why I have said that arrest under GST is a controversial aspect. See, there are numerous judgments in India given by the Honorable Supreme Courts and many other High Courts about guidelines about arrest. Okay, now the GST authorities, many a times there were many instances where they have failed to follow the already settled instructions given in CRPC. Now the important point why I want to highlight the due process of law was, you forget about GST authorities are not even following the procedures, but the court itself is saying that forget about following the procedure, whether the procedure established itself is correct or not also we will check. So in my humble opinion, in GST arrest there is a lots of chances of arbitrary action by the department. Many arrests which are happening under GST are arbitrary in nature. Okay, so the courts, being the right to life and personal liberty being a fundamental rights, the courts are very strict while when it comes to the matter of arrest. Any scope of arbitrary, they are not considering the actions taken by the government, and they are giving immediate relief to the persons who are accused or who are remanded. Okay. In many cases, generally, in general, after the arrest, the arrested person should have to be produced before within 24 hours before the magistrate. Many a times GST department is not following that. This is a settled thing. Not only this one, there is one more important aspect which I am going to reveal now, which is very very important in my humble opinion, where we can challenge many arrests which are happening under GST. Okay, now let us move on to the last part of the discussion, and a very very important, that is a recent judgment by the Karnataka High Court in the case of Viral Narendra Gosalia versus Senior Intelligence Officer. This was a judgment given in Karnataka High Court. Now what is so important about this judgment was, it was a settled principle in India. Many a time Supreme Court had said, and many High Courts had also said, that it is a settled thing. In case of economic offences, offence of economic nature, and where the punishable and unpunishable with imprisonment of not more than 7 years, okay, in such scenarios, the person who has been accused of this offence should have to be served a notice under section 35 subsection 3 of BNSS or section 41A of CRPC. Now what is this? For example, in GST, we have seen clause 1, section 132 subsection 1. What is the maximum imprisonment permitted there? It is 5 years. It means in GST, it is an offence is economic in nature, and the maximum imprisonment that can be given was 5 years, right? It means, will I fall in this category? Yes, you will fall in this category. Now the moment it is an economic offence and the maximum imprisonment is not more than 7 years, the department before arresting should have to issue me a notice under 41A of CRPC or section 35 subsection 3 of BNSS. Many a times department is not doing this. See, the moment you are not serving this notice, the arrest itself is not proper. You have to serve me this notice, and even after serving the notice also, you can arrest me only when there is a proper another reasons which are recorded to be in writing. Based on the general grounds of arrest, you cannot do that. Whatever the conditions you have given in 41A CRPC and 35 subsection 3 of BNSS, if I am not complying with that, and if I am not cooperating to the investigation, then only you can arrest me. In this case, what happened was, the person accused of this offence was arrested. Okay, and the petitioner argument, that is the accused or the person arrested under this case, their legal counsel argument was, they didn't serve as notice under section 41A CRPC or section 35 subsection 3 of BNSS. Why is this required? Because the maximum imprisonment that can be given in GST was below 7 years only. Thereby, serving this notice under 41A CRPC and 35 subsection 3 of BNSS is very much required. You are not following. And also department tried to cover up this by saying that the summons which we have issued under section 70 is in the nature of 35 subsection 3 or 41A of CRPC is what the argument that the department had put before the Karnataka High Court, which the Karnataka High Court had rejected. Summons issued under section 70 is to gather evidence. How can you call it, how can you equate it with a notice being issued under 41A CRPC, which is being done in the course of investigation? Generally, this 41A CRPC notice and 35.3 BNSS notice will be generally issued during the course of investigation when I have a clarity that an offence had happened and this person might be involved in this offence. I want to investigate. In such scenario, I can use this 35.3 and 41A. Whereas the purpose of section 70 summons was different. To understand what had actually happened, I will issue summons. Thereby, section 70 summons cannot be equated with section notice under section 35.3 and 41A of CRPC. This is what the Karnataka High Court had said. This is going to be a protecting weapon to many of the taxpayers for arrest under GST. Okay. Now, why I have taken these are the aspects that I want to cover under this video about arrest. My final points of arrest was, see, the right to life and personal liberty which was guaranteed by Article 21 was very important to all the citizens. So whenever these fundamental right is being taken away or it is being abridged by any law, Article 13 will come into picture to save you from that arbitrary action. So in my view, in my humble opinion, based on the research that I have done, many arrests in GST are violating the fundamental rights. Thereby the arrest in GST is becoming more controversial. So these Article 22, Article 21 and also the settled principle of giving notice under 41A of CRPC for economic offences where the punishable imprisonment is less than 7 years is another undisputed weapon in the hands of the taxpayers to save them from the arrest. So this is my understanding which I want to share with you about the arrest. So if you really feel this video helpful, you please give a like and also share your feedback to the form of comments. Thank you so much. Namah Parvati Pataye Har Har Mahadev Shambho Shankara. Thank you. Jai Hind.